Welcome back to Singing Back. This is the third and the last part of the Michigan Supreme Court hearing we've been listening to and discussing. This is the state of Michigan versus Jade. It's a so-called child predator sting operation case. And remember, this hearing is about defining what is entrapment and what it is not. Today's episode covers the rest of the prosecution's arguments. If you listened to part 2, you've heard the first half of what the prosecution presented. This now is the second half of that. I'm A, and with me here is my co-host M, and also Norm from ICAC Unpacked. So here we go.
And if the police are the ones who initiate sex, why is that not the entrapment? And here they initiated the
Great question.
sex and the 15, and the thing that made that sex a not just a crime of soliciting sex on the internet, but a 20-year felony because of under 16.
Yes. So I guess while it would be possible that really the part of the difference is that skip the games, and the record supports this as well, is although it's possible there could be an outlier of someone seeking cuddling, it's pretty explicitly and solely relevant, or it's limited to the context of the solicitation of sex. And so that, I guess, by defendant already being on that website and already approaching the decoy, he is at least engaging in a conversation knowing that this context is surrounding it. And then they're talking about where to meet up. Prior to any discussion of age, there is no, there's nothing of him saying, oh, I just want to cuddle. There's none of that going on.
No, but I'm analogizing, like, again, to the police decoy on the corner of a high drug traffic area, right? Yeah. Odds are the person walking past that might approach that person or talk to them are maybe seeking drugs, but there's also people who aren't. And even if that's a rarity, right? Like, the point is the police can't make that person, whether they're, would be willing or maybe interested in getting drugs, or somebody who isn't, they can't manufacture the crime.
Right.
So why is it, even though you're on
Nice
a site that
she mentions willingly and manufacture the crime. The exact same thing that Petrosky mentions: willingness and versus manufacturing the crime. Willingness to commit it versus manufacturing it. Very good questions.
And her point is that even though this is like an escort service website, yeah, it's obvious that, many of the users there are likely there seeking to pay for sexual encounters, but not all of them are. Some of them might be just looking to cuddle or just go to dinner or things like that. And that's especially why the police should not be offering sex to them. It would be like, a drug sting. Yeah, maybe most people that walk through there are looking to buy drugs, but not all of them. And that's why it would not be appropriate for police to be standing there offering drugs to people. Hey, you want to buy drugs? Because by doing that, they are creating the crime. They're supposed to wait for somebody to approach them and ask for the drugs, right? But it's not supposed to be obvious that they're out there, looking for people, offering the drugs to the people. And that's, they manufacture the crime the second they choose to offer the person, the drug, the sex, the illegal sex, the whatever the crime is. That's what her point is, that they're manufacturing the crime by doing that.
4 out of 5 dentists would be looking for sex, but also maybe not, right? And again, if they're initiating it, maybe that's a different case. And I understand Mr. Doman saying that is still entrapment, but that's, I guess, a different case. But why is that not the equivalent? That if here, to me, the significance is both the sex, which is the lower level crime even, and then the escalation to the 20-year felony was initiated by the police.
So I guess I kind of have two parts to how I want to respond.
So before we let her answer, just to be clear, she's like, when she says first is sex, that means the paid sex. Okay, because that itself, is a crime. But she's saying, but then police turned that into like a 20-year felony, is what her point
Right,
is.
right. It's probably a misdemeanor. And
Versus a
right.
serious
Oh,
felony. But
and
that's what her
yeah,
point is. How is it
soliciting an adult versus soliciting a child.
right? Why is that? And she's asking her, why is that not entrapment? She says
Right.
she's got two parts to her answer. Let's see if she really answers that question. Why is it not entrapment that the police then turned that into a 20-year felony?
First, law enforcement, when they're similar to in Williams, when they're engaging, in this more general investigation into a type of criminal activity being facilitated in a specific forum, they ultimately are adjusting or the manner in which the investigation proceeds is based primarily on how the suspect responds to the mere presentation of the opportunity. So if the defendant, if in the present case the defendant stopped the conversation, law enforcement, and the record I believe also indicates this, that the law enforcement didn't know his name. They had his phone number, but they didn't know if that would be like a real phone number. They had no information. So he was ultimately under zero pressure to completely stop communicating. But because instead of doing that, he engaged, or he furthered his engagement, and then ultimately, when without any pressure from law enforcement, decided to drive all the way to the hotel, that was ultimately, that's how law enforcement, even though he was engaging in conduct sufficient to constitute CISA by simply continuing to discuss make the plans to continue soliciting the escort for sex after knowing that she was a child. Ultimately, even after that occurs, then law enforcement doesn't plan on making the arrest after he simply tries to say, no, you've got to be 16. That's not when they do it. Ultimately, they're tailoring their investigation to only essentially arrest or go seek out suspects who are so ready and willing that they are willing to drive all the way
What
there.
happens when he says,
I like how
Sorry, I
they
thought that was
say,
you.
no, go ahead.
Okay, so she did you catch when she says, you know, she puts she puts it all on, the target. He could have just stopped the conversation, and at
Yeah,
that point, police don't know who he is. They don't
right.
have his name. They leave it alone. They
They
wait
they
until
they
he
could
shows.
geolocate him though. They could use the ISP. She knows full well all that. But
Well, that's what I was
this
going to
thing,
point out. Either she's very ignorant about this, or she's intentionally lying and covering it up, because a lot of times they do know ahead of time who you are, or from the beginning. They're looking up
yes.
your phone number, they're looking you up, they know who you are, and they're on it. They're not going to just, and they spend a lot of time on that, and that's why they're not going to just let it go, because it's
And
like, we got this one. Once they got you, it's very hard for them to let you go. So when she
yeah, tell
says,
me about it.
they should have
They
stopped the conversation, well, Norm, isn't that exactly what you did? And then
but
they came back.
well, yeah, it doesn't matter. I mean, I didn't even have any sex talk, and it did not matter. But you notice how she mentions to they continued their investigation. Or maybe she said started, but at what point, so they get to create the circumstances under which they have an investigation, and now it's a full-blown investigation where they have to find out all these things,
So what she
right?
calls continuing the investigation is, oh, now that we've got him, curious about this, let's now,
Well, now
further
it is an
induce him.
investigation, but
But
at
well,
what
they call
point
it
was it an investigation?
it's not an investigation. She calls it the investigation. She says, well, they continue their investigation, but
Well,
what
that's
she
what I just said. So if they continue, at what point did it become an
it
investigation
never
if they
was.
were just trolling to begin with?
It never was. That's my point.
Yeah.
That they call
Right.
it an investigation, but this right here shows that it's not an investigation. They're calling it an investigation, but what she is calling an investigation is actually further inducement from the police. Okay, now that we've hooked him and he's continuing to talk to us, then we're going to talk more sexually to him. We're going to demand a sexual conversation. We're going to demand that he talk to us sexually before we give him the address for when to meet us. This is what they call their investigation. So there is no investigation. That's just them playing the game of lure him in more, so that we can arrest him to get him to show up. That way we can claim that he took a substantial step to supposedly sexually assault a minor, because that's what they call that. And that's bottom line. That's what this is, that they are calling things, the terms they want to use that are not really applicable to what truly happened. Any other comments before I move on?
No.
No. Can the government take the next step and say, you want to think about it? Or what happens when he says no?
So it ultimately, it is a fact dependent, so we'd have to look at everything. But if he says no and the government, I think, again, context is relevant. I think it's in like the videos that CDAM provided, they mentioned that one of the suspects would indicate.
Yeah, context is important, and we have to look at everything when we're on the line, when we're on the ropes. Context, very important. Have to look at everything on the whole. But boy, they don't give you that option, I noticed.
Right.
Not
Context
at all.
matters.
No way. Every little thing is a movement toward crucifixion.
Yes, context matters when it comes to us presenting our side, is basically what you're saying.
Hilarious.
But when it's the defendant, we don't want you to consider the context of, why he said the things he said and why he showed up. Let's throw out context then. But I want to hear.
Flip it. Let's flip it. How, if she was being completely honest, how it would have gone when that judge asked what happens after he says no.
Right.
Real scenario is that cop goes, oh, well, let's nudge him just a little bit more.
Right.
What, are you chicken? Let's talk about it a little bit more. That's what the decoying police officer does.
They start attacking your manhood.
Right.
They start attacking your manhood, like, you're not man enough to do this. Are you scared? There's nothing wrong with it. I've done this before. I'm just going to find somebody else. They show that they're very desperate for the sexual encounter, and they, start pushing harder for that. If you stop talking to them, if you block them, they create a different account and they come back after you. Because I've heard that story many times. And Norm, you were one because you did report them, and then they created a different account and came back after you again. So I want to see what she says. She's being too clever
by half here.
What was that?
She's being too clever by half here because, Bernstein's question again is right on. Okay, well then, how far do you want to take this? What if he says no? Because remember, the words of the federal statute are coerce, entice, induce, or persuade. And also remember, there are, in the Curry case, there are like 5 steps of potential entrapment. These guys talk about 12. But one of the major factors in either the 12 step or the 5 step is whose idea was it for the criminal conduct, the police or the subject? Was the defendant working for some kind of profit? Was he reluctant to commit the offense is another one. And that's what he's getting at on this one too. And was the nature of the inducement what the government did or what he did to himself?
Right. So let's see what her response is to what happens when he says no.
He was going to drive to the hotel, decided not to because of weather, because of the inclement weather. And so in that circumstance, it might be, and again, it would need to be evaluated under the totality of the circumstances, but ultimately that would be evaluated differently than if the suspect simply said, no, I don't like kids. And then the government continued to try and push them.
As they often do.
Yeah. So do you see how she just defined it as you have to specifically say, no, I don't like kids. Otherwise, you are guilty. If you don't specifically say, no, I don't like kids, then you are guilty. Even if you don't show up, if you didn't go, they're still going, unless you said, no, I don't like kids, which they'll still keep trying. If you didn't say those words, they're going to keep coming after you. So she just gave it away right there.
And
That's the
even
standard they use.
yeah,
If you don't,
and even if you do that, then and it's in the record, miraculously it will not show up in discovery.
hmm
It'll
so
somehow be removed from the discovery. I
oh,
mean,
that's
we have a lot of people that we all know, all three of us, who are fighting hard to get the discovery and are mystified that the prosecution, the police can't get it on time, fights them every step of the way, won't, it should be no argument. You have everything that can make me look bad and everything that can make me look good. No arguments, but they fight tooth and nail to hide the evidence so that they can get the conviction. It's a monstrous betrayal of the Constitution.
right. And it cannot be more clear that it has to be a part of their training to hide that evidence, to hide that
Yeah. Oh,
exculpatory
absolutely,
evidence,
without a doubt.
because it's happening across the nation. And you know the
In every
majority of
case.
these the majority of these sting operations, and even in the sting operations that the vigilantes conduct. So it's clearly a part of their training. This isn't accidental, this isn't careless. They're doing it on purpose. That's exactly what makes it a scam.
Also, too, the idea of the escalating someone's criminal culpability from the idea that that is reprehensible is I'm not arguing that in the slightest, but in particular when we examine, especially when we examine cases where law enforcement engaged in escalatory conduct. Generally speaking, that is when law enforcement knows that the suspect does not have the requisite criminal culpability, like in People v. Killian, where the defendant was a user of cocaine but not a seller of cocaine, and law enforcement had every reason to know. In those
Again, fall
circumstances,
back to the drugs.
the law
What was that?
That's all I was going to say. Again, she's falling back to a drug case of escalation instead of using a more analogous case where they are, in effect, creating the escalation.
True.
law enforcement knows that the defendant does not have the requisite criminal culpability and yet still makes the decision to target them for investigation, in knowing that they would have to engage in impermissibly inducing conduct in order to cause or induce them to get to commit the offense. And so that's really where the escalation of the culpability becomes a problem, is because law enforcement is making the determination that it is appropriate or that it is even a good decision to make to choose to engage in behavior or conduct to escalate that behavior. And so if law enforcement does not know what a suspect's existing culpability is, they cannot knowingly engage in behavior aimed at escalating it.
Counselor, if we're really focused on law enforcement's conduct, and let's say it wouldn't be entrapment if they have guardrails in place, such as not raising the issue of sex, such as training the people, such as recording everything. Let's say there are standards and practices that protect the integrity of these operations.
Dun, dun, dun.
Those aren't honored, such as in this case, where there are lapses in following the standards that are supposed to protect the integrity of this. Doesn't that suggest that we're over the line at that point? And if not, why not?
So I have two sort of parts to my response. So first, in the present case, because this was a training operation, Genesee County was basically showing Van Buren County how to conduct these investigations. There were not policies necessarily in place, so there were not.
Oh, wait, did we miss that? There were not policies necessarily in place because Genesee County was in the process of teaching this.
Buchanan County.
They were teaching them
Buchanan County.
This other county or something how to perform these sting operations. Because of that, there was not necessarily any policies in place.
Well, that's problematic on several levels. But remember, these judges are human beings. They go home, they hear the news. The ghost unit out there has been heavily criticized for its methods. And as I predicted a number of times, when these folks are getting more and more desperate, and when they're competing against other law enforcement, they want to look like, the badasses on the beat. So they may go a little bit too far. And if they do that a couple of times, the courts are aware of what's going on. They see that. But it's funny if they wanted to be protected by, they know that these procedures that are in the ICAC training manual and stuff wraps around their neck like an albatross, and they're not interested in that at all. But boy, if they worked in their favor, they sure would embrace them. So again, she's got a
Exactly.
tap dance right on the line here.
Exactly. Is it just another coincidence that something that would have worked against them was just not in place or is just missing? Like the audio evidence and video evidence goes missing, or, the other entire chats that happened before leading up to the sexual conversation. That stuff conveniently is just not there. So you see the pattern here. This is another example of this. Oh, we just didn't think about it, and so those policies were just not in place because this was just training. But the defendants, it's real. They really were trying to hurt children, even though this was just supposed to be training. We still arrested them and prosecuted them and ruined their lives, and so it's just oopsies that there was no policies in place. And you'll hear her say, therefore, there were no policies violated. How convenient, huh?
That could be violated. There were not policies in place for law enforcement essentially to violate in order to induce the conduct of defendant. I know that that's not the most satisfactory answer, but there weren't the
No,
policies.
we were reckless instead.
Yes.
Were policies in place, and law enforcement then chose to either not to ignore those policies or to try to sidestep them. That would be.
Wasn't there a suggestion in the record that the officer who was involved here thought there should have been some additional checks, or there would normally be additional checks, and that wasn't present here? Isn't that the kind of lapse I'm talking about?
Yeah, yes. And most notably would be the error or the oversight that really sticks out, in my opinion. It was the oversight in failing to record the phone call. But ultimately.
Oh, did you hear that? They failed to record the phone call in this case, too. Oh, wow, what a coincidence. That happens in so many of these cases. I wonder if that is part of their training. Hey, don't record the phone call where you really push the sex really hard on the men, because that's going to show inducement. So make sure you don't record those so that if you don't have the evidence of inducement, then they can't use it against us.
Yeah, that's a good point.
Ultimately, because we are here, we are evaluating this case under the entrapment doctrine, entrapment defense, we really need to evaluate whether these mistakes or these errors of law enforcement would amount to reprehensible conduct or impermissibly inducing conduct. And conduct needs to be reprehensible would have to be dangerous, criminal, or immoral acts, which ultimately an oversight, a failure, a mistake doesn't reach that standard of true reprehensibility.
Oh, it was just a mistake. It was not reprehensible,
Right.
even though it's a pattern and this is seen in so many of these sting operations across the nation. No, it's not that they're being trained to hide this evidence or to not
We're
have
only
any
depriving this
policies.
person of 20 years of liberty,
Yeah.
potentially.
Yeah, so I think going back to our question before, is she gaslighting on purpose? She knows what she's doing, or is she just incompetent and doesn't really understand what she's dealing with? This part right here shows that she is gaslighting on purpose. It's just an oopsies, it's just a mistake. We should not be judged for it. Yeah, the problem is that it's the same mistake we see over and over again throughout these cases across the nation. So it's
Well, how many
clear.
times have we heard law enforcement say, yeah, didn't do this or we didn't do that? And, again, it comes down to what I said at the beginning. Courts are people, and they have pre-existing thoughts on what they ought to do. I think of the Ryan Pick case where they did not have a 15-second video of Omegle from the waist down only. And but the nice police officer was good enough to describe it for the judge, and that was
Mhm.
just fine. Now,
Right, because
Pitt's
they don't lie.
attorney fought this like crazy, and the judge shut him down because it's ridiculous that you should be allowed to simply describe it.
Mm-hmm.
Remember, testimony from a witness is admissible,
Yeah, and
and
that's
they put that right up there with as if it were a picture is worth 1,000 words.
And that is exactly what they will do, Norm. They'll say, "Oh,
Yeah,
we didn't record the
I know.
conversation, the phone conversation or the video, but we have the transcript of it that
Yeah,
we created ourselves.
right.
And you should just
Yeah.
believe and trust what we say." And this is a very common thing seen in a lot of these cases. And in fact, there was a case in Washington state that was dismissed because they did not record the audio
As
call,
it should be.
as it should be. Exactly. And that judge knew, and so they dismissed the case. So it's interesting that she points out that in this case, same thing happened. They didn't record the phone call, but here we are. The case did not get dismissed based on that hiding that evidence, right?
That Michigan jurisprudence requires for entrapment to be established under that prong. And then also, using the failure to record the phone call as an example, while undoubtedly an error, that would have in no way induced or caused the defendant to go forward with committing the child sexual abuse activity.
Oh, really? The phone call would have in no way induced the defendant to go forward with this because you know that even though it wasn't recorded and you have no idea what was said
Well,
or not
the
said.
phone call might let us know what the hell's going on with it.
Ex-
Um,
exactly, because in a
and
lot of
and
times,
surely you would want that because it would prove your point.
because in the phone call they might have said, "Okay, fine, I'm 25, but I like to pretend to be
Right.
15." And
Right.
right, and we don't know that because
Yeah.
that phone call is missing, and there is a very good reason why that
Well,
audio recording of that phone call is missing.
she's got about 2 minutes and 15 seconds. I can't remember how it ends with the questions.
Had no expectation that the call would or would not be recorded, and he didn't know
But
law
wouldn't we
enforcement was
know
involved.
what it said and whether he was in fact induced on that call?
We know what the
We don't know
stipulated
now?
facts state, and so the stipulated facts are fairly limited, but they ultimately, there was no indication from the stipulated facts that there was really any further discussion of sex or any inducing or reprehensible conduct occurring on that phone call. So
And where did those stipulated facts come from?
Yeah, she pulled it out of her backside. How do we know, and how can we be assured of that?
Because a
Because
lying
they say
police
so.
officer, what was that in?
Because they say so.
Yes,
Exactly.
exactly. Right, right.
Because a lying police officer said it themselves, and you're supposed to believe it, even though it's clear that this is a habit of, part of the pattern we've uncovered of how this works for them.
So since we're limited to the record, ultimately we have no record support indicating that there was anything untoward happening.
Would you agree, though,
Convenient.
that the policies, whether they were in place for this conduct or not, the purpose of the policy and why the police would employ them is to avoid a situation
Right.
where
Exactly.
there's entrapment?
That's
Where
why you
kids
have
are
it.
gonna get
That's
thrown
right.
out, right? So don't do these things because
Right.
we're gonna be held to have entrapped.
And that's, yeah, exactly. She says, otherwise, because if you don't follow those, then the case can get thrown out. So that's
Well,
exactly why they don't have those policies, because it's
right.
like, no, we didn't violate any policies. Well, because the policies don't exist. Had the policies, been in place, then you can show they violated their policies. Therefore, this case gets thrown out.
Policies protect people and institutions from liability. That's why you have policies. Somewhere I read in a court case a number of years ago, if you have a practice that you regularly follow, whether it's a concrete written policy or not, that becomes your policy. So maybe the policy is not to have a policy, thereby to be able to twist in the wind whichever direction seems to get you what you want. Law enforcement has been getting away with this shit for a long, long time in this and many other types of cases.
And you know that they're training also, they don't have written training about this in Michigan. I assume it's the same in other states. They have video training. And
Yeah.
so that's interesting too. And that way you cannot refer back to like the paper training guide that says you need to follow this or that. It's just all video. You sit here, you watch the video. Okay, now go and do it. They don't have it in front of them, like the manual, the guide to refer back to know, what they can do and cannot do. And that's also conveniently designed because it's designed to be entrapment. And they don't want us to be able to prove it. But they're being uncovered now.
But they also have access to a DA, so they can call the DA and get some guidance on this.
Yeah, but those DAs, where these sting
Yeah,
operations are conducted, they are also they also attend these trainings where they are
yeah,
trained to do this. That's
right.
part of the problem. The DAs in the counties where this is happening, they're in on it.
Yeah.
And this case goes away.
Yes, and that's why excuse me, yes, those procedures generally are in place to protect against these sort of arguments or issues arising and to protect the integrity of the investigation. Ultimately, in the present case, it would have been better if those policies and procedures were in place. They just, quite frankly, weren't at this point.
Oh, darn.
Growing pains aren't a great explanation, but ultimately this is what we're left with. Generally speaking, though, different police departments and law enforcement organizations do have policies and procedures in place. I believe Genesee County does have policies and procedures in place, and so those are ultimately there to protect the integrity of the investigation and the rights of the suspects and defendants.
Counsel, so let's take these facts here. Obviously, you believe, it didn't cross the line. What else would have to happen for this to be entrapment?
Now they're trying to narrow the scope.
We've kind of
Go ahead.
I just said they're trying to narrow the last few questions from the judges are trying to narrow the scope. It appears to me that they've made their decision. They're just trying to get a sense of where the guardrails or the parameters are. But
Right.
isn't it interesting? You are Buchanan County comes to you because you're the local experts, you're successful, and you're the man on these things, and they want to be the man too. So what does Genesee County do? Teaches them all the wrong ways to do it. And,
Yeah.
abstract ways. Gee, I don't know, try this. I mean, come on. That's not what they did. They had very specific things that they told Buchanan County you can do to be as successful as us. That's exactly what they did. And she does not want to go through and relate all those because they will be crucified before these justices because they're all geared toward entrapment.
Yeah. So now that she's explained her side of why this was not entrapment, so now this judge is asking her what would make it entrapment. So in order for it to qualify as entrapment, what would have had to happen? So let's see what her answer to that is.
touch on it a little bit, but if the defendant instead of if he had said, oh, I'm not, I don't want to mess with a 15-year-old, no.
See, there it is again. The only way it is entrapment is you have to specify the words, I don't want to do this with a 15-year-old. I don't like 15-year-olds. Never mind the fact that they are totally behaving like a consensual adult who can fully consent to this sexual interaction, even though they call themselves a 15-year-old. But even, if they are sexually throwing themselves at you like no real kid would ever do, it is still your job to say, oh, no, because you said you're 15, even though it's not likely that you are, then I have to say no. And that's BS because that's where we cross into our First Amendment rights.
So we are to believe that the target has to follow a specific format and policy.
Right.
But
So
we don't. But I can tell you in my case and in many others, I said no immediately, every which way from Sunday. And the only thing you hear is them relaying what happened in the last few, like 2 hours. And they weave it together in a narrative that didn't exist and didn't happen that way. Okay, they took strands of this and strands of that. And if I had had justices who were like these people, where they said, "Well, wait a minute, if you weren't there to begin with, there wouldn't have been anything." And he did say, after all, he's not interested how many times. And he never said he wanted to get together for the purpose of having sex. Okay, and he only agreed to say this until after you had said this other thing. I mean that's what you need. But here again, it seems like it's burden shifting in a way.
Right. She's supposed to explain what the government would have had to do in order to make this entrapment, because this is supposed to be on the government's conduct, and she shifts it back to him, to the
Right.
defendant. Oh, this is what the defendant should have done, and then it would have been entrapment if the government had proceeded, I guess. Let's see what she says.
Thanks, and they say, oh no, come on, please, like it's not that bad. Or they were to make like a promise that no, actually it's legal, don't worry. Like any of these sort of things.
Which they do. All
They
of
do all
which
of that.
they do.
They do all of that, exactly.
Yes.
Trying to pressure or trying to, there is case law stating to overcome the will, but basically.
So he said nope, has to be 16.
Right.
So why was that not enough to say, okay, I've got to drop off now?
Exactly.
Because that was the exact kind of conduct that's being investigated under the Child Sexual Abusive Activity Statute, because she was under the age of 18.
But they weren't investigating it. That's the thing. They were trolling.
Yeah, they were, and point out the fact that it's because in Michigan the legal age is 16.
Right.
So he was saying that because he knew that the legal age of consent in Michigan is 16. What he did not know is that only applies to if you are talking, soliciting them in person. If you are soliciting them in person, for a sexual hookup and they're at least 16, then it's totally legal. But if you solicit them online for a sexual hookup and they are under 18, then it's illegal. And
yeah, I think you said that in the part one of the episode too, which I found that surprising. Very often people get confused because the legal age is 16, but they'll have a codicil in the law like they do in Virginia. If it's, I can't remember, more than 5 years or 7 years or something difference, then it doesn't really matter that they're 16.
Yeah, that's the problem. That's part of the problem with some of these laws is like, had this been a real 16-year-old, if he had talked to this 16-year-old in person and said, hey, let's hook up, I'll pay you or whatever, or just consensual, no paying, that's consensual, totally legal. But because if you text about it or you talk about it online, then that turns it illegal, which is ridiculous. So this guy was showing that he wanted to follow the law. He just did not understand that the law actually, does not apply the same, to in person versus online. Because it was online, now it's illegal. He was thinking it's totally legal to be with a 16-year-old. This 16-year-old obviously wants to have a sexual hookup, legal age of consent. I'm not trying to break the law here. That's where he got mixed up in this, because he was thinking it was totally legal. He didn't know that it was under the 18 if it's online, illegal.
Okay, so for this case.
For this case, yes.
Fine.
And
okay, there's a whole bunch of cases CDAM has provided us where I don't believe it's the same conduct. So, and there are examples, I think, of the defendant saying, I don't think I'm interested, but then there's still engagement. I know I'm in a tough spot.
Yeah.
So
no, and that's okay. Again, it is a very much, because of the highly fact-intensive nature, it is a case-by-case analysis. But ultimately, it would be, including the Joulette factors, but not limited to, looking at the conduct of law enforcement to see if they were engaging in active measures aimed at basically inducing or causing the person to commit the crime. And so if you're, in cases similar to this one, where all they're doing is saying, I'm 15, they're not engaging in any conduct that would actually induce or cause someone to commit the offense. In other circumstances, if they're, appeals to friendship, appeals to sympathy, or even maybe like using extremely low prices, you could maybe make an argument for that. But those are ultimately those are the circumstances surrounding the presentation of the mere opportunity, which ultimately was considered by both the trial court and the
So
Court of
if
Appeals.
the defendant here had said, sorry, not interested.
If he had said, sorry, not interested, and law enforcement continued, then yes, that would be a much more, that would be a much clearer indication of.
So she just admitted. So that judge is saying, basically what you just said is entrapment. We've seen that in other cases, and those guys were still
Right.
convicted. Um, so yeah, so that proves to this court that that the definition of entrapment is not well established, because to her that would have been entrapment supposedly, or she says, I don't believe it, but she says it. And the judges are like, but wait a minute, we've seen other cases where exactly what you're saying should have qualified as entrapment. Those guys were denied the entrapment defense, or the entrapment, or it was ruled that it wasn't entrapment.
Yeah.
And so that's awesome that she fell right into that trap
of entrapment. Thank you. All right. If there are no further questions,
Thank you.
thank you for your time.
And we used up all your rebuttal, so thank you for your arguments. The case will be submitted. I'm calling our.
Okay, so that is the conclusion of this. What do you think? Any final thoughts?
Ma'am?
Our policy is there is no policy. Policy schmolicy.
I think what this particular one did better than the Curry case is it really exposed the fundamental questions that those of us who have been stung or who have loved ones who have been stung have been saying for some time. We're not lawyers, we're not great legal minds, but there's a certain sense of unethical treatment and violative treatment, whether you want to call it constitutional or ethical or moral. And at the same time as we've had to fight for our own reputations and our own morality, we have a court here who is finally onto it and not letting the prosecution twist this around, or in this case, whichever side you're on at the appellate level, twist this around and make it a circus where the subject, the target, is dumped on even more by having to explain everything they do, always in the context of grooming or soliciting or some other nonsense. Even when they claim that the police have a certain responsibility, they don't really, they let them off the hook more. And it's refreshing to see some of these questions aired in public by judges who clearly are aware of what is going on out there in the real world.
Yes.
And go ahead, Em.
No, I was agreeing.
And it's refreshing to see that this prosecutor, proved exactly what we've been saying over and over again. They're full of BS. Like she said, she was straight out asked what would it take to make an entrapment, and the response she provided showed that that's not true, because those cases where that has happened, those men are still being entrapped. Those men are being charged and prosecuted and convicted. And so that it's very good to see that that's on the record now,
Well,
for
what we
the
need
lawyers.
to see is whether, what they're going to decide here. I mean, we know what they decided in the Curry case. They came back with a very quick decision. Even though a lot of the fundamentals are quite different from this case, but a lot of the conclusions are along the same line. And I'll be very interested to hear, what they come back with on this. And this case should give people heart all up and down, certainly in Michigan, but elsewhere too, that you know, they're slowly but surely things are changing for the better. Slowly but surely, people are realizing that it is not what the police are saying. and that everybody who's caught in these things is not a vicious, vile predator lumped into the same cases as Alicia Kozak or Jacob Wetterling or Adam Walsh cases. They're not the same at all.
Not even close. This does give me hope that this may be the beginning of the end to the sting operation scam that do not protect children from online predators the way they've been claiming. And hopefully, this is the beginning to getting this fixed, getting them stopped, or at least fixing them to where they are doing it the right way and they're not targeting innocent men who were not looking for children online, who were never a danger to children
Right.
online, in person, or anywhere, and who would have never harmed a child like that. And then, once they fix that, then they need to move on to fixing all the harm and damage that they've done to all the people they've done this to with the scam.
Yeah.
That's what I think about that. It gives me hope, and hopefully it continues to get better from here.
Thank you for tuning in to Stinging Back. Stay tuned for more. Check out ICAC Unpacked with Norm. And hey, read a lot of our comments. Please make some more comments and subscribe.
Thank you for listening, and don't forget to keep stinging back.